GM, hello, and welcome to another episode of TacoBytes, your daily bite of Degen. Episode number 362. You start losing track of these after a moment, and we're just so this close to 365 and beyond. We actually got to check to make sure that 365 is not tomorrow. We thought we started this a year ago, but we will go find through with a fine-tooth comb everything that we sort of found. This is sort of what we have going on today. We are going so there's two amicus briefs from on behalf of Coinbase, in support of Coinbase against the SEC. And so one of the things that we sort of wanted to go and sort of find out, go through it all document by document. So but we wanted to sort of cover all of it and have that fun piece with you. And so we are going to do that today as we get ready for this. We got to find it, all the fun things. Then we have something rather interesting, a new game that we might share with you. And so, this is sort of what we're doing right now. Let's see here. We got to say good morning. And we got some fun things going on all the way around. Let's see, we'll go with this bowl. And then we're going to go with GM America. So we do want to do quick shout outs. One, this is your daily bite of Degen. We're streaming to two YouTube channels. So hello to our YouTube fans that are watching, to Twitch, to Discord, to Telegram, video, even into Twitter. And at the same time that we're doing that, we are also streaming to some fun times. Let's see here. Video. Oh man, did we get attacked by Mev already? Yeah, we did. Oh man. So one of the big things that to our two of our families that are really important right now, our Xenon family as well as our Unlonely app, and so it's just sort of really cool to see how you're able to build out a community in other profile and other protocols and stuff like that. And so but this is the fun, boring thing. Sometimes we have, out of all of these really cool protocols and stuff like that, we get to go through some of the regulation stuff, go through the non-pretty, I guess you could say, just so that we can make sure that, a well-rounded picture of what's going on in the market is going on, so people know and can be prepared for what's coming up. And so one of the big things we just sort of wanted to go over tonight was that amicus brief. So that was filed for on behalf of the Hal Schuster and Goldberg out of New York. And then there is a whole list of the people that went through it. We're going to go through this, and we also want to showcase this with you guys as well, so that you can see what this amicus brief is about as well. And let's see, where did that go? Boom. Put that there. And last but not least, our Twitter page. Boom. Let's see, where is that at? So that is sort of the big things that we are looking at right now. So this amicus brief, we're going to go through it. I will give my opinion pieces on it. You know, it is a 24-page document. A lot of it is really laid out really cleanly. I like it as far as documents go. They laid it out. So the amici curiae, you know, are law professors and scholars who are experts in securities law and related fields. They include the authors of leading securities law casebooks and numerous scholarly articles in this area. Amici have a professional and scholarly interest in the careful application of the securities laws and bring to bear an understanding of the history of the securities laws that they hope will be helpful to the court. So, and the amici, so those that are filing on behalf of or in support of, so we have Stephen M. Brainbridge from William Warren, law professor at UCLA School of Law. Tamar Frankel, professor of law, Emirata, Boston University School of Law. Sean Griffin, professor of law, Ford Law School. Lawrence Hammerschmidt, professor emeritus, Widener University, Delaware Law School. M. Todd Henderson, the Michael J. Marks Professor of Law, University of Chicago Law School, and Jonathan Macy, Sam Harris Professor of Corporate Law, Corporate Finance, and Securities Law, Yale Law School. The AMSI joined in this brief in their individual capacities only, with institutional affiliations listed for identification purposes only. Introduction: to determine whether the tokens traded on Coinbase and through Prime constitute unregistered securities. This court must determine whether these unusual instruments, not easily characterized as securities, land, earth, timber, are investment contracts, and as such are one of the enumerated types of securities covered by the Securities Act of 1933 and the Exchange Act of 1934. The answers require the application of the Supreme Court's seminal decision in SEC versus Howey in 1946, which held that an offering in a Florida citrus grove coupled with the right to receive a share of the grove's profits constituted an investment contract and hence a security, because it involved an investment of money in a common enterprise with profits to come solely from the efforts of others. And so one of the things where, and so Howey, this test is meant to embody the essential attributes of a security. One of the things that came to my mind when I was sort of thinking on this, and this was being read to me for the first time, was solely from the efforts of others. So nothing from yourself. I just want to point out, like, the very first thing that projects ask you to do, is go raid tweets, go post about it, go meme about it. And so what's really crazy is that, and I just sort of thought on this, the other day, so we're putting in all of this effort as an individual buyer, because we are not investors, as an individual buyer. And so literally it is from the effort of ourselves and what we're willing to do and use within our own network, to look for profits, because we are in the financial industry, in it for profits. Blockchain is so much more than just that, which is really interesting, really cool. And what really sort of, drives me with some of the way tech is being used these days. But at the same time, one of the sole tests is that it comes solely from the efforts of others. So if you're putting effort into it yourself, does that defeat the Howey? and so that's just something random, thought on it. And so we will see, this test has been in Howie. The court held that by including investment contract in the federal securities statuses, Congress used a term with a well-settled meaning based on judicial interpretations of state blue sky laws. As a result, to assist the court in assessing how investment contract was understood by Howie, and at the time of the federal securities status enactment, MSI offered their analysis of how the team was interpreted in the state blue sky laws. Hold on 1 second. So, that analysis makes clear that an arrangement is an investment contract only if the investor receives, in exchange for an investment, a contractual undertaking or right to an enterprise's income, profits, or assets. That core notion has carried through in the federal cases since Howie. So, second part here, a contractual undertaking or right to an enterprise's income, profits, or assets. Is that in the case? That's what's sort of being fought. Is that the case with some of the tokens that are listed on Coinbase that the SEC states are securities? Solana, Matic, Filecoin, Chia, a handful of others, that just, you're like, what? Why? So then from there, when Congress included the term investment contract in the definition of security, that term had a well-settled meaning from the blue sky laws that required a contractual undertaking to deliver future value. When Congress adopted the Securities Act and Exchange Act, virtually every state in the union was already regulating securities transactions by way of state statutes. In defining a set of national standards in a scheme of federal regulation, Congress chose to enact federal legislation patterned on these so-called blue sky laws. Most relevant here when defining securities, and then just so people understand, blue sky laws are state anti-fraud regulations that regulate the offering and sale of securities to protect the public from fraud. The laws require the registration of all securities offering and sales, as well as of stockbrokers and brokerage firms. The term blue sky laws comes from the words of Kansas Supreme Court Justice Dolly in 1910, who wanted to protect investors from speculative ventures without more basis than so many feet of blue sky. The laws vary by state, but typically require sellers of new issues to register their offerings and provide financial details of the deal and the entities involved. So we sometimes see that as different forms of paperwork, that are offered, from prospectus to anything in between. Most relevant here when defining securities subject to the new national securities legislation, Congress imported the term investment contract wholesale from those blue sky laws. In Howie, the Supreme Court confronted the issue of which arrangements qualified as investment contracts under the federal securities statutes. Acknowledging that the term was undefined in the Securities Act and the Exchange Act, the Supreme Court looked to the state courts to assess how they had constructed the term investment contracts in their blue sky laws. Based on a survey of leading state court decisions, including Gopher Tire decisions from Minnesota, the court found that the meaning of investment contract had been crystallized through those prior judicial interpretations. In light of that, the Howie court held Congress intended for the term investment contract to carry the same meaning given to it by the state's courts interpreting state blue sky laws. With that context, we surveyed the development of the concept of an investment contract under the blue sky laws that Howie invoked as the basis for the term's uniform definition. States enact the first round of blue sky laws. At the turn of the 19th century, as the American economy had boomed, so did the market to transact in shares of American enterprise. John Macy, Jeffrey Miller, Origin of Blue Sky Laws, middle class and retail investors flocked to big exchanges in New York and San Francisco to buy stakes in the commercial enterprises of industry titans, from railroads to heavy manufacturing. But as market opportunities for blue chip stocks grew, so did the offers from questionable sellers and speculative or outright fraudulent ventures, like fly-by-night concerns, visionary oil wells, distant gold mines, and other like fraudulent exploitations. Unlike their blue chip relatives, these offerings were often sold face to face by newspaper or even mass mailing. Unsurprisingly, efforts to sell stakes in these ventures were often plagued by clever puffery and fraud or deceit. Beginning around 1910, state legislators responded to these developments by enacting the nation's first round of securities law. Macy Miller coined blue sky laws. These initial legislative efforts to regulate securities sought to protect the public from dishonest promoters who would sell shares in the bright blue sky itself. So almost like the Eiffel Tower being sold over and over again. If someone could sell it in a way, someone would, and so the term blue sky was that people would try to sell the sky itself if they could. Through the statutes varied state to state, they typically sought to regulate the sale of traditional securities like stocks and bonds, and they did so by requiring state registration to sell them. Or as Justice McKenna put it in Gregor Jones, these laws were aimed at speculative schemes which have no more basis. For more background on these blue sky laws, see Macy Miller. The first blue sky laws were relatively bare bones. They did not specify precisely which instruments they covered. Consider Kansas's 1911 Securities Act, credited as the first blue sky law. Brenner versus Oppenheimer is simply barred investment companies from selling any stock, bonds, or other securities of any kind or character without first registering them. The Kansas statute did not otherwise define the term security. Other states sought to provide a bit of color as to what qualified as a security. Initial statutes in California and Wisconsin, for instance, specified that security meant traditional instruments like stock certificates, bonds, and other evidence of indebtedness. Defining security as any bond, stock, or note, or other obligations or evidence of indebtedness. Legislators quickly saw a need to adopt second-generation securities laws. Indeed, many of the unsavory, speculative, or fraudulent investment deals or schemes that triggered the enactment of blue sky laws in the first place were technically not stocks or bonds. Much like the promoters of the Citrus Grove deal at issue in Howey, enterprising businessmen and less savory types often sold a stake in a commercial enterprise by mimicking conventional stocks, offering a bundle of contract rights, guaranteeing a share of future enterprise income, profits, or assets. An entrepreneur in Georgia, for instance, offered investors the opportunity to buy fig orchards from him for $600. And in return, he would promise, by contract, to grow fig trees on their plots and to pay them 3 cents per pound for all fruits grown on said trees. Though not a traditional security, at least as a formal matter, these pseudo stocks worked in like fashion. They proposed to give an investor, in exchange for an initial amount of money, a contractual right to obtain an interest in the future value of the enterprise, just like a stock or bond. Nope. They were not clearly and they were not clearly subject to the first generation blue sky laws, given the focus of those laws on actual stocks and bonds. States broadened blue sky laws to include investment contracts. Recognizing that these new instruments or offerings shared key economic and legal features with stocks and bonds, state legislators sought to regulate them expressly in second generation securities laws. Famously, Minnesota included the term investment contract in the definition of securities, regulated by its 1919 Blue Sky Law. Minnesota's registration requirements applied to stocks, bonds, investment contracts, or other securities. Emphasis added, quoted in Gutterson-Pearson. This new undefined term was intended to capture those investments that, though not formally stocks or bonds, depended upon and gave a contract right training on future profits. Other states quickly followed suit, also adding investment contracts to the list of instruments subject to their blue sky laws. Minnesota interprets the term investment contract in Gopher Tire. This was an interesting case. Although, as noted, the term investment contract was not defined in the statute itself, courts quickly filled out a definition tracking the intent and context of the adoption of this statutory term in the Blue Sky laws. In several early Minnesota cases, including those cited by the Supreme Court in Howie, the state Supreme Court examined the key features noted for an instrument or set of rights to qualify as an investment contract. Those pronouncements were and are seen as authoritative of the original meaning of the term. In Gopher Tire, a local tire dealer had sold certificates in its business to investors. Under the deal, investors would pay $50 and agreed to promote the dealer's goods to others. In exchange, the investor received a certificate that gave them a contract right to receive a percentage of the dealer's profits. Parsing the Blue Skies law's definition of security, the court held that the certificates were not technically or formally stocks. Even so, the Minnesota Supreme Court held that the certificates may properly be regarded as investment contracts. In so holding, the court reasoned and emphasized that the certificates had the same key features as stocks. The investors provided capital to the dealer, and in return, the investors obtained by contract the right to share in the profits of the corporation. Put differently, the certificates were contracts that induced an investment by promising a share in defendant's profits, which the investor received in exchange. Other early Minnesota cases adhered to this early judicial test defining the statutory term. In Bouchard, the Minnesota Supreme Court confronted another dispute over whether a contractual profit-sharing arrangement was an investment contract. There, a bus driver paid a bus company $1,000 and in return received a contract promising the driver guaranteed wage plus the right to receive a share of the bus company's profits, in addition to eventual return of his $1,000 investment. Citing Gopher, the court held that this arrangement was an investment contract based on two factors. The driver invested with a view of making profit, and in exchange received a contract securing the right to future profits in the venture. He invested with a view of making profit, and the operator's agreement was the contract. The Minnesota High Court again applied this standard in Kirst v. Nelson, finding that a vineyard sale contract was an investment contract because it entitled the buyer to a share of the proceeds from the resulting grape sales. Oh, got a ding. Where's the ding? There it is. Yep. All right. So, on that basis, the court found the vineyard sale contract was an investment contract because it entitled the buyer to a share of the proceeds from the resulting grape sales. Purchase of vineyard plus a contractual right to proceeds from resulting grape sales. As the court's syllabus put it, this sort of instrument was an investment contract because it was a contract for investments in a profit-sharing scheme. Much the same in State v. Ogden, the Minnesota Supreme Court explained that investment contracts were ones that evidence a right to participate in the proceeds of a venture. On that basis, the court found that a statement and purchase for units in an oil venture qualified as an investment contract because unit holders were to participate in profits in proportion to their holdings. In sum, the early Minnesota case centered on two statutory terms, contract and investment. An arrangement qualified as an investment contract if the investor received a contractual undertaking respecting the commercial enterprise of another, whereby in exchange for an investment, the investor was promised a right to share in the future income, profits, or assets of the enterprise. Other states converge around the Gopher Tire standard. As the Minnesota High Court adhered to the investment contract standard articulated in Gopher Tire, the courts of other states followed its lead and adopted definition of an investment contract. As the Supreme Court noted in Howie, the Gopher Tire standard was uniformly applied by state courts to a variety of situations where individuals were led to invest money in a common enterprise, with the exception that they would earn a profit solely through the efforts of the promoter or of someone other than themselves. So, just like I talked about earlier, I actually didn't hear this part yet. So coming to this is rather interesting, where I was talking about with projects that, require, part of, drinking the Kool-Aid is promoting the project in and of itself. It states here that one of the tenets of the Howie test is that implies the appreciation of investment as well as a contract. Solely through the efforts of the promoter or of someone other than themselves. So, indeed, this was a common strand running across each of the state cases cited by Howie that involved an investment contract. The term investment contract implies the appreciation of investment as well as the contract cited by Howie. Investment in return for contractual right bonus share of profits from land of sale contracts. Contractual right to offset land purchase price with profits from crops harvested on land. Contractual right to receive a specified sum on a specified date as principal and earnings. Highlighting the need for contractual entitlement to the seller's later profits, other state cases found that an investment contract was missing when there was no such entitlement. Consider Lewis v. Creasy Court. There, a grocery wholesaler offered local stores a deal whereby they could pay $300 in exchange for the right to buy groceries from the wholesaler for only 5% above cost for a period of 20 years. This was no investment contract, the Kentucky High Court held, because the wholesaler had not promised to give the participants in the deal any part of his future profits. Said differently, the purported investors did not retain any contractual right to profits in exchange for their investments. That was the key missing ingredient. As the court explained, this feature of investment contracts, a post-sale obligation on the part of the seller to distribute a share of the profits, is what sets investment contracts apart from standard contracts like automobile sales and contracts involving the exchange of commodities that the state securities laws do not regulate. Other state cases were in accord, holding that asset sales were not investment contracts because they provided no post-sale entitlement to a share in another's future profits. Consider McCormick v. Shively, which concerned an agreement to purchase a plot of land in Mexico in installments, where the seller retained a small interest in any crops or other resources produced from the land. The court held that this was not an investment contract, explaining that only such contracts shall be considered investment contracts as provided for the payment of money at a future time. So let me reread this. Other states were in accord, holding that asset sales were not investment contracts because they provided no post-sale entitlement to share in another's future profits. Consider which McCormick Shively, which concerned an agreement to purchase a plot of land in Mexico in installments, where the seller retained a small interest in any crops or other resources produced from the land. The court held that this was not an investment contract. So basically, someone was selling someone a piece of land, but breaking it down, the payments down, they, in return for allowing that land to be sold and paid off in pieces, they got a piece of the profit from that land. So really cool idea there, piece. The court held that this was not an investment contract, explaining that only such contracts shall be considered investment contracts as provided for the payments of money at a future time to the purchaser or holder of the contract. So since it's backwards, the seller and their future income. By contrast, the real estate contract at issue imposed no obligation on the part of the vendor to do anything other than to deliver a deed upon the payment of the purchase price. Though the seller retained a proprietary interest in the land's output, the contract still did not grant to the holder any sort of expectation in the future income, profit, or assets of the business. On the same grounds, another Minnesota Supreme Court decision rejected a bid to classify a real estate transaction as an investment contract. There, an enterprising individual, later the defendant, secured oil leases in Texas. A group of individuals, later the plaintiffs, joined together and bought all of the leases via a trust from the defendant, each plaintiff holding a stake proportionate to their buy-in. But the promised oil did not materialize, so the plaintiffs sued under Minnesota's blue sky law. Just like in Lewis, the Minnesota Supreme Court held that there was no investment contract, rebuffing the suit. The court explained that the challenged instrument was a simple purchase of an interest in lands. Although there were apparently some suggestions by the defendant that he might form a related organization and issue stock, there was no actual agreement to that effect. In other words, without a surviving obligation for the defendant to return proceeds to the investors based on defendant's profits, this was merely an asset sale. Under the contract now before us, the complaining witness could not expect any return for his money on account of anything done by others, nor because of his investments alone. His profit must accrue, if at all, from operations conducted by himself. By the time the Securities Act and Exchange Act were adopted, there was a settled meaning of the term investment contract. By 1933, when the Securities Act was enacted, 47 of 48 states had passed their own blue sky laws, and many of those covered investment contracts, following Minnesota's lead. And in the decades before 1933, while applying that investment contract term to various arrangements, the state courts converged on a uniform meaning. That is the meaning Howey explained that Congress adopted, U.S. Code 328 U.S. at 298. In short, by 1933, the state courts had converged around a standard for interpreting the term investment contract to mean a contractual arrangement that entitled an investor to a contractual share of the seller's later income, profit, or assets. Indeed, to our knowledge, it appears no state court decision found an investment contract without those key features. In some decisions, like Heath, courts openly suggested that investment contracts require an actual contract. The term is not defined in the Act, but it implies an apprehension of an investment as well as of a contract. In other decisions, courts stressed the key requirement that the seller be obligated to pay and the holder be entitled to receive a share of the seller's future value in exchange for the initial capital outlay. And courts routinely relied on this requirement to distinguish true investment contracts from basic asset sales. Following Howey, federal case recognized that investment contracts require an expectation in the income, profit, or assets of a business. In the over 75 years since Howey was decided, courts have applied the Supreme Court's seemingly simple test to all matter of novel and complex commercial circumstances, yielding a complex web of case law. The common thread remains, as it was in the state court decision interpreting state blue sky laws, and as Howey required, that an investor must be promised, by virtue of his or her investment, an ongoing contractual interest in the income, profit, or assets of the enterprise. In this section, we discuss some of these cases. The Howey test requires consideration of whether an offering resembles the ordinary concept of a security. The Supreme Court had interpreted the term investment contract several times, including, of course, in Howey itself. Each time in applying the Howey test, the court considered whether the transaction reflected the essential attributes of what is commonly known to be a security. In particular, the court has considered whether the offering resembled the ordinary concept of a security, a phrase drawn from the House report accompanying the Securities Act, explaining that its definition of investment contract permits the fulfillment of the statutory purpose of compelling full and fair disclosures relative to the issuance of the many types of instruments that in our commercial world fall within the ordinary concept of a security. The term security was meant to include the many types of instruments that in our commercial world fall within the ordinary concept of a security, and that the court also considered how the arrangement compares to other instruments previously held to be securities. Take, for instance, Foreman. There, the court observed there was no distinction between an investment contract and an instrument commonly known as a security, another enumerated terms in the statutory definition of security. It held that shares in a nonprofit housing cooperative were not investment contracts because the investors were motivated solely by the prospect of acquiring a place to live and not by financial returns on their investments. In reaching this conclusion, the court extracted the meaning of profit embedded in two of its prior investment contract decisions and concluded that there was no expectation of profits in the case at hand. Marine Bank provides another example. There, a couple had guaranteed a loan for a meat company with certificate of deposit in exchange for the right to a share of company profits and the right to use its facilities. The court held that neither the certificate of deposit nor the subsequent agreement between the couple and the company were security. The court concluded that the certificate of deposit was not a security because it bore important differences from certain interests deemed to be securities in Tepper v. Knight and long-term debt obligations, commonly found to be a security. The agreement between the couple and company was likewise held not to fall within the ordinary concept of a security because it was a private transaction rather than an offering to multiple potential investors, as in prior cases. There was no contract right to receive profits in the future based on the efforts of others. Here, the case law, both from the states before 1933 and from the federal courts after 1933 underscores that for there to be an investment contract, the investor must obtain some contractual stake in the enterprise through which a profit is possible. Every investment contract identified by the Supreme Court involves a contractual undertaking to grant a surviving stake in the enterprise. Echoing state court decisions under the pre-1933 Blue Sky laws, post-Howey Supreme Court decisions recognize that a holder of an investment contract must be promised an ongoing right to participate in the income, profit, or assets of an enterprise. The court homed in on this theme in International Brotherhood of Teamsters v. Daniel. There, the court observed that in every decision of this court recognizing the presence of a security under the Securities Acts, the persons found to have been an investor chose to give up specific consideration in return for a separable financial interest with the characteristics of a security. The court found no separable financial interests with the characteristics of a security on the facts before it. Specifically, it concluded a non-contributory compulsory pension plan was not a security because the pension benefit argued to be a security was only one small piece of the overall non-security-like compensation the individual received by virtue of his employment. To date, every arrangement the Supreme Court has deemed an investment contract promised the investor some ongoing contractual interest in their enterprise's future endeavors, which predicated Howey by 3 years, involved the offering of leasehold interests near a planned oil drilling test well in exchange for investors sharing in the discovery values of the ongoing exploration enterprise. Howey itself involved the offering of plots of land in a citrus grove coupled with a contract for the promoter to harvest, market, and sell the citrus in exchange for remitting an allocation of the net profits based upon a check made at the time of picking. The first two post-Howey investment contract decisions, SEC versus Variable Annuity Life Insurance Company of America and SEC versus United Benefits Life Insurance Company, involved annuity plans under which investors contributed premiums to an investment fund managed by a life insurance company and were entitled to a proportionate share of the gains. Variable annuity life, noting the investor obtains a pro rata share of what the portfolio equity interest reflects, noting that investor is entitled to his proportionate share of the total fund. TechPrint involved the offering of withdrawable capital shares in an Illinois Saving and Loans Association, the purchase of which entitled investors to become members of the association, vote their shares, and receive dividends declared by an association's board of directors and based on the association's profits. And finally, Edwards involved a sale leaseback scheme in which a promoter offered payphones along with a site lease, leaseback and management agreement, and buyback agreement, and investors received the right to receive a fixed 14% annual return from the day-to-day operations of the payphones leased back to and managed by the promoter. Let's see here. Wait, what was this? A sale leaseback scheme in which a promoter offered payphones along with a site lease. Okay. Every investment contract identified by the Second Circuit involves a contractual undertaking to grant a surviving stake in the enterprise. Likewise, every investment contract identified by the Second Circuit has involved a contract granting a surviving stake in the enterprise. Interest in movie production companies that return profits to investors secured by operating agreements. SEC via Aquasonic Productions. Franchise-like sale agent agreements that promise holders profits from sales of dental devices. Whiskey sales deal that promise to pay back investors with proceeds of sales. Real estate co-op arrangements where rental income from professional offices and buildings offset monthly rental rates. Co-op shares that return to holders proceeds from renting co-op rental units. Certificate of deposit that provided return of cash investment. Interest in limited partnership agreements. No Supreme Court or Second Circuit decision has found that a scheme without no Supreme Court or Second Circuit decision has found that a scheme without accompanying contractual undertakings qualifies as an contract. At times, the SEC has argued that under Howey, an arrangement can be an investment contract even if it lacks a contractual undertaking to deliver future proceeds. So part of the Howey test is stating that to meet the Howey test, it has to promise or fail the Howey test, to be defined as a security, that there is an undertaking to deliver future proceeds. But if there's no contractual undertaking to deliver future proceeds, then it doesn't fall as a security. In this case, the SEC has argued that even at those times when future proceeds are not promised or talked about, that it can still be defined as a security. And this was in Binance Holdings. So case law, June 13th, 2023, pre-motion hearings. Howey Bridge suggesting that investment contracts feature contractual arrangements. For similar, this argument hooks into the Howey statement that an investment contract came to mean a contract or scheme for the placing of capital or laying out of money in a way intended to secure income or profit from its employment. The SEC has suggested it by referencing both contracts and schemes. The court and Howey must have meant to capture within the term investment contract arrangements that did not involve any contractual undertakings. But nowhere does Howey suggest that it was doing away with the core contextual and historical anchor of the statutory term investment contract, contractual undertakings. Rather, Howey's reference to a scheme or transaction simply reflected the instruction that courts should consider the economic reality of a business venture to determine whether an investment contract exists. That economic reality may be reflected in a single agreement. For example, a single profit-sharing agreement, or as in Howey itself, which involved land sale, warranty deed, and management contracts, multiple contracts. Not surprisingly, no decision of the Supreme Court or the Second Circuit has ever found that a scheme that does not involve a contract could qualify as an investment contract. Likewise, none of the surveyed state law cases, including those cited by Howey, held that an investment contract existed without a contract undertaking regarding later proceeds. That has been the key ingredient distinguishing investment contracts from other arrangements since the term first appeared in the Blue Sky Laws, in Howey itself, and ever since then. Conclusion. In interpreting the term investment contract in the federal securities laws, the court should adhere to the settled meaning of the term, consistently applied by the state courts interpreting state Blue Sky laws, as well as by the federal appellate courts before since Howey. Under that settled meaning, an investment contract requires contractual undertakings to deliver future value reflecting the income, profits, or assets of a business. So all of that sort of breaks this down to an investment contract requires contractual undertakings to deliver future value. So meaning that someone goes under term that they are going to work on behalf of by earning into this. So a really interesting piece there. So this is sort of, and this was filed August 11th by the Howell, Schuster, and Goldberg, by Vincent Levy. So it's an interesting take on it. And, we might actually try to contact Vincent Levy next time we're in New York, and hope to see if we can get an interview with him, sort of see a little bit more of an opinion or talk about what this may mean and what this really has going for it. So really interesting piece here. What I want to go to now is someone I really think provides a lot of value, and that is Caitlin Long. And one of the things, let's see. So the Fed objected to New York's approval of the PayPal stablecoin, but they have no jurisdiction to affect. So it's interesting states are pushing back into this. Let's see here. Where is it? Ooh. We might want to go look in that for a minute. Let's see. Let's see here. Where is this? Do 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 do. Let's see here. Where is Caitlin? Sort of. Um, let's see here. Um, do 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 do. So this is here's where we start to get this. Let's see. I can't really say enough how graphic to get support from so many. I would say thank you, appreciate the effort, and this is from the attorney for on behalf of Coinbase. I know they are proved useful to the court in understanding the legal errors the SEC ways. Let's see here. There are good reasons for bonds to rally. Let's see. Nope. Coinbase. Let's see. Is this it? So this is all anti all things crypto stance is risky to the federal agencies. It drove them to engage in bet the farm type litigation in which courts could actually reduce their jurisdiction, but they chose this path, and that's an interesting piece. That's an interesting take on it too. You know, where Caitlin has really put a good sort of spin on it, because this could give legal ground for other people that have fallen under the hammer of the SEC to be like, wait, we're like this too. And so by overstepping their bounds too much, or, they might not even think that they're overstepping their bounds. I hate to say this, and I'm going to say that they could be like a Karen, where they think that they're in the right. Maybe they're not trying to do evil, you know? Maybe they are trying to do what they think is best for the American public, But then what that makes me think is that they just think that everyone's really dumb, you know? And they think that people are too stupid to protect themselves, too stupid to have control of their finances, that they need to live in debt. And that's one of the scariest things out there on this. And so, ruined that a little bit. Sorry. And so we see, let's see, let's make sure we fix that. Boom. Yeah, that looks good. So we see a really scary piece here where the courts may put the SEC thinks it's doing right and think it's protecting people and looking out for them. And, then it just, that the government has no faith in you or me as human beings. And then that goes back into what political parties are attempting to do and how they're attempting to set up the future for their predecessors. Because a lot of them are playing that long game. So it's really interesting to see. And someone wrote, I don't think they understood regulation of crypto at all, which has a very high social media component. Banks downplay the regulatory issues and the fines they pay. Crypto media is social media, for better or worse. I think better transparency. So cool to see. You know, um, and so it's sort of scary to see the outcomes of that. We think you're too dumb to handle this, so we're going to take it all away and not let you play with it. And then we're going to hand it over to someone else that has more money than you. And just because they have more money, they obviously know what to do with it. So I think that's just a distribution of wealth that hits an unfair pattern again. So we'll see how this turns out. Really want you to, if you really have a view of what, of having a voice, I thought we were following Coinbase. I don't know why we're not following Coinbase. I think we were following Base, but let's see here. I really would love for you to stand with crypto and make sure that your voice is heard. What Coinbase has done is they've made a really simple way for you to put in your address or your zip code, find out who your senator is or your congressional your representative are, and just sign, digitally sign and send an email to them so that you can have your voice can be heard. And then what's really cool is anyone that has the Stand with Crypto NFTs can actually vote in Base DAO, Nouns DAO grants. And so really cool to see that going. Really hope that a lot of people partake in that. Really interesting to see how the Stand with Crypto NFT plays out, both in value and use cases within Build on Base. The other piece that I want to just end on tonight is because we're going to have a bigger space tomorrow. First principles of crypto, education, and Zen. Have the chance to do 2 learning educational pieces for around 50,000 people. Around 15, on average, 15 to 40,000 people take these courses. And these are really simple, learn and earns done in, 2 minutes. But have the chance to create 2 educational content pieces, which is going to be really exciting. So I hope you follow along with that. We'll be making a separate Twitter page for that. So that it is not, intertwined with, the weird things I post on Twitter. It's really interesting to see how this will turn out. So I want to thank everyone for their support. We will see you next time. And as always, we end with, our favorite words of wisdom and the best, worst knock-knock joke on the face of the planet. And what that is, you know, um, closed mouth cannot be fed, and you cannot feed a closed mouth. Meaning, if no one knows you're looking for opportunity, opportunity cannot come a knocking. If opportunity does come a knocking and no one answers, it's going to keep on walking. Um, you just raise your chances of a yes simply by asking. People aren't going to know you need something until you say something. And then at the same time, uh, I just want you to have fun, have questions, always ask. We're here. Um, and we will see you guys on the flip side. We got some amazing conferences coming up: Rare Evo, Permissionless, Breathe, Masari Mainnet, ETH Global, maybe something in New Orleans, and that just rounds out September. A month and a half. We will see you. But as always, we leave with the greatest, worst knock knock joke on the face of the planet, and that is knock knock. Who's there?